Hi, my name is Mujola Oluwa and I welcome you back to Bar Talk with Ola. Ola is from Mujola Oluwa. Please don't call me any other short form but Ola. Don't start your questions or your comments or your emails with Mujo or Mujola. That's not the short form. The preferred short form is Ola, Ola Oluwa, or Jola in the extreme. Now, we want to talk about a very important topic today, something that affects both layman and lawyer and law students. We want to talk about Champerty. Champerty. Champerty is a phenomenon that is, very dicey and very interesting. Let's say now two people are fighting, A and B. Now you come in as C and you're telling A or you're telling B, come on, you can go to court, you can win. I will fund the lawsuit on the condition that when you win, you will pay me this amount of money. That is Champerty in its simplest form. Essentially, you're an investor, you're investing in lawsuits, you're investing in litigation for gain, of course, as an investor. So you're fomenting strife, you're fomenting litigation for gain. That is Champerty. It is not to be confused with consulting with someone, a client as a lawyer, helping them understand their options at law. It is also not to be confused with advising someone as a layman to enforce their rights in the court of law. What distinguishes Champerty from any other thing you're doing, that may result in litigation or that may look like encouraging litigation, is that you undertake to pay the cost of the suit on the guarantee that you get or share out of the proceeds of the lawsuit. So that is Champerty. There's a fantastic case in Kensington, Egbo and Escort Paints versus Ugbebo. In that case, the respondent, Mr. Peter Ugbebo, was a chartered accountant, and then he was retained. His services as a chartered accountant was retained by Kensington, Egbo and Escort Paints for a suit that they had against Union Bank of Nigeria. So they wanted to recover 65 million naira from Union Bank, and they retained his services as an expert to give his opinion. So to give expert opinion regarding the matter in court for the sum of 100,000 naira and 15% of the judgment sum. So when they won the case, they contested that they only owed him 100,000 naira and that's what they were going to pay. So he demanded for 15%. They were saying that, oh, you only gave evidence as an expert witness. It was the judgment of the court that gave us this 65 million naira, not your efforts. Then he insisted that no, we had an agreement and you have to fulfill it. Then they now said that, oh, it's a Champerty's agreement, it cannot be enforced. Then he contested that I'm a chartered accountant, that only applies to lawyers. I rendered my services, I'm entitled to 15% of the judgment sum. So he sued them. Now, there's a separate case that they've won. Then he now sued them for the enforcement of the 15%. And then the court held in his favor. Then they appealed. And on appeal, he was contesting that he rendered his services as a chartered accountant is entitled to payment as agreed. They were still saying it's Champerty, you cannot enforce a Champerty's agreement, which is something they actually made with him. But now that the judgment was ripe for the harvest, they did not want to share it. The court held in his favor again, and the court held that it was not a Champerty's agreement because it was not funding the litigation. So the very important element of Champerty is that the third party must be funding the litigation in hope or expectations of profit. So Mr. Peter Ugbebo was not funding the litigation. They only had an agreement as to a share of the proceeds of the litigation. And so the court held in his favor and held that it was not Champerty. Generally, Champerty is regarded as a form or a type of maintenance. And the maintenance element is very important. That is the element of you maintaining the lawsuit, bearing the cost of the lawsuit with a guarantee of gain, or with a condition that you will profit from the fruits of the judgment or the fruits of the lawsuit. So that is where Champerty and maintenance, that is where they meet, but they are different one from the other. Now, Champerty is very illegal and frowned at largely because it can lead to different things that are undesirable. That's why it's generally considered contrary to public policy. For instance, if you're undergoing to bear the cost of litigation with the expectation of gain, there's a high likelihood that you would be manipulating the entire process. You could be suborning witnesses, that's bribing or inducing witnesses to tell lies on the stand, perjury. You could also be suppressing evidence that would make sure that the case does not go in your favor. You could do a lot of things that tamper with a free and fair process. That is why it is frowned upon, because it's different if you just want to, out of your goodwill, out of generosity, out of consideration for another person, help them bear the cost of litigation. But where it is qualified by an expectation of gain, by an expectation of returns from the proceeds. Now, you're not even talking about just the money that you spend. You're expecting profit as if it's an investment. That is when it becomes champerty, and that is why it is wrong, it is illegal, it is frowned upon. Largely in Nigeria, you may not find a decided case on champerty. You may not also find any particular law that sets out champerty as being illegal, but it is generally frowned at. If you look at rules 50 and 51 of the RPC, it qualifies champerty to an extent. Rule 50 talks about a lawyer being able to actually make arrangements, a contingency fee arrangement with the client. Contingency fee just means you're saying that the client can pay you after the job. So probably, and it's usually maybe for clients who cannot really pay at the moment, you can make an arrangement for them in civil suits only. That's what Rule 50 permits. You can make contingency fee arrangements so long as it is not contrary to public policy and it is reasonable, and so long it's not vitiated by fraud, by mistake, or by undue influence. That means that it must not be a fraudulent agreement. The persons that are making the agreement, the lawyer and the client, must not be operating under a mistake of fact or even of law. That is, they must be clear as to what they are getting themselves into. There must be no undue influence, no manipulation. You may be wondering, what is contingency fee? Contingency fee is just an arrangement that you make as a lawyer with your client to say that you will get paid after the successful disposition of the suit. Now, it differs from champerty because you're not undertaking to pay for litigation with the hope of gain. What you're saying is, what you would have paid me, I will collect it when the job is done and we are successful. That would also mean that when the job is done and you are not successful, you don't get paid. So that is a contingency fee arrangement. An arrangement to say, upon the successful disposition of this lawsuit, you pay me. So they are basically going to pay you from the proceeds. You're not going to profit from it, but they're going to pay you what they should have paid you at the beginning. That is a contingency arrangement, a contingency fee arrangement. And the law, the rule for lawyers says that it is allowed in section 50 based on the criteria that I have enumerated earlier. 51 also then says that a lawyer must not bear the cost of litigation. That means that as a lawyer, you cannot say, oh, this suit is going to cost you 50,000 naira or 50 million naira. I'm going to pay it so that when we finish, you pay me. No, but you can advance some sums. So now, the tricky part is this. You cannot bear the cost of litigation, but you can agree, you can make a contingency fee arrangement to say you pay me when we are successful. If we are not successful, that means no payment. Also, the law actually permits you in 51, Rule 51, to say that you can advance some expenses. For instance, the cost of going to court. Maybe you are a law firm, the client cannot pay, but you've gotten an appearance date. You could send a junior, you could go. When you come back from court, the client can pay the appearance fee, or you can pay the cost of going to court, or you could file and then the client can pay the filing fees. So what he's saying is not that you bear the cost. What he's saying is that you can advance the cost and the client can pay you, maybe out-of-pocket expenses or some other expenses. But generally, you cannot enter into a champerty agreement. You cannot foment litigation with the hope of gain. That's the long and short of champerty. Essentially, all we've been saying is that champerty, where there's no written law in Nigeria that prohibits it, there are some rules of professional conduct that go against it, and it is generally against public policy, in the sense that you cannot foment strife, pay, sponsor litigation or strife in the hope of making gains from it. It would be or appear to be a general blanket, covering and prohibiting third-party litigation funding, but it is not. People still fund litigation by third party. Class actions, sometimes election petitions are usually funded by the party, So, but one could argue that the party has some interest, in the matter, and insurance companies sometimes fund even maritime cases, and some other cases, for their clients. But one could argue that they also have some interest in the matter. While Champerty is stricto sensu someone that has no interest, zero interest, a third party, properly so-called, coming in to fund the suit, to promote the suit, a promoter, an investor coming to invest with the hope of profit and the hope of gain. So that is Champerty. I hope you understand it. I will see you in my very next video. Don't forget to subscribe and let's continue the conversation in the comment section. To-dos.